Hi guys, it's Kathy. I hope you're doing well. So we got a soft sit today, but he's not an in-your-face constant soft sit. First off, what we have to go through is a very confused man. And he's confused because he just refuses to listen to what's going on. He thinks he knows what's going on, and it's not matching up in his head. What's going on is not matching up what he feels should be going on, so he's just confused. So we bumble around the court for a while. Then his soft sit comes out. Then he's confused again. Then his soft sit comes out. Then he's confused again. I forgot to make the title UK-ish. Son of a gun. It's fine. It's fine. Let's just get into it.
Morning, sir.
Grand Rising.
We're set for sentencing again today, or actually status of counsel.
Yes.
What are your thoughts on that?
Well, given my current state and just shoulder out the other work, so on and so forth, it's been difficult just paying bills, and I can't, retain Christopher. So, I need to get back to what I need to do. So I probably didn't get it. It's
Are you asking for a public defender, or are you representing yourself?
I'm still pro se. Has anybody retained?
I'm asking, did you want the public defender's office to represent you if you can't afford an attorney because you're off work because you're shorter?
I've had good luck with that in the past, if you don't already know. No, and that's no offense to anybody. A second.
He's thinking. It's very hard for him. It takes effort.
Given these circumstances, it has been quite a while. I get that I broke our contract with the state, but in my own rights, because it wasn't working for me, feeling like that it was not, that I was getting ready to relapse because of some of the stuff that OPON, makes you go through in these worksheets and stuff, which the probation officer, he had stated, I went through X amount of sessions at OPON, but it doesn't show the continuance of my Fridays that I went voluntarily for over a month and a half, which was like 6 or 7 more sessions after, I had spoken with my counselor.
The question again is, do you need an attorney? That's the question.
And withdrew. And then the whole probation thing, I told you about the incident being there, which he still wasn't able to verify, because I did sign in, but I went there and wasn't able to wait to urinate and ended up urinating on myself, and left. I mean, I haven't had much faith in this. So I did file this the other day. Stamp. Give you, I don't know, one.
Yeah, I'm just not going to talk about it. I have to provide it to you. So I guess you didn't really answer the question, but you're proceeding pro se, and we're going to sentencing now. Is that what we're doing?
I was kind of going somewhere with that, but I'm declaring my rights to be asserted. It's federally and Indiana state constitution both say this. I'm trying to do what's best for me. I'm following a guideline in this contract that just wasn't working with these rights asserted. And then I have I have every ability to keep my well-being, or to keep my best interest, for myself. Uh, the contract, the right to contract and uncontract. I mean, was my declaration of rights asserted. The contract wasn't working. I told you I felt like I was going to relapse. But I mean, failure to of consideration. It seems one-sided. I have to follow it this way, even though I still got to the same end result. Being sober and not invading anybody's privacy and the same end result was still passed, given all this time. But I mean, let's void out any shields of failure of consideration to the contract.
There's a fight in the hallway.
I'm demanding an appeal from a higher court because my side still hasn't been heard. I've been given a lot of options, manipulated options, as well as people running their mouths, things that weren't true that led me to this the very beginning with Melissa McCrae and the invasion of privacy and whatnot. I mean, I have facts, and this is a de facto court, correct? They lied. I've got cameras that show that all of these allegations were incorrect. As far as the invasion of privacy, I mean,
The underlying case is not before the court at this time. We're here on the violations of probation. An evidentiary hearing was held in November, and we made a finding, and we're here for sentencing. That's what we're here for. So, do you have anything to say with regard to that sentencing?
Like, do you want a lawyer still? We're still waiting on the answer for that.
you do. This is already in place with
That's all those.
the appeals court. In fact, could we postpone the sentencing hearing then for 30 days until I get back with him?
I'm sorry?
The demand for the appeal.
Yeah. No, that's appeals from a final judgment. We haven't had the sentencing yet. We have to have the sentencing. We have to get that done. You have a right to appeal your finding on the evidentiary hearing, but we need to move the case along. We'll just pause it and wait for the appeal.
No. I mean, the demand for the appeal, goes with. You're not seeing my side of the story here. Again, I understand that the contract was broken. I've asserted my rights, and I won't. I mean, I'm a living, breathing creator, and I assert my rights, not to be compelled under.
He changed the script to, I'm a living, breathing creator. And he's not to be compelled.
Any contract, commercial agreement, that I did not knowingly or unknowingly, willingly, and voluntarily consent to. I don't accept the liabilities associated with these presumptions complied to consent of an agreement. Okay. Because they weren't working for him. And
He is guilty of a probation violation, which means he's been guilty of another crime that he got probation for. Then they had a hearing about his probation violation, and he was found guilty. So we just need to do the sentencing for that. But he's a living, breathing creator, so it's hard to do.
and I'm not like,
And his shoulder hurts. Let's not forget about his shoulder. That's very important.
picking on anyone. Again, I have my needs in my best interest I mean, there's no grace here, with the state, in seeing that I've gone above and beyond, given all these things going on. In the meantime, in finding a purpose, as well as healing, and again, the end result is still the same. Where's the grace, Your Honor?
Normally a level 6 felony, 6 to 30 months of incarceration on the front end. You were given grace in that you were given home detention as opposed to Department of Corrections. You were given grace in that you were given probation instead of Department of Corrections. So there's grace. State any thoughts on something?
I completed the home detention.
It was nice.
Just one thing to note, Your Honor. I guess if I understand what Mr. Knapp is asking for regarding appeal of the conviction, I believe he is well outside the 30 days to file a notice of appeal. As far as sentencing on the PTR goes, Mr. Knapp has asserted his beliefs and how he believes that impacts his duties under the sentence in this case, which I comprehend. However, if he is unable or unwilling to comply with terms of probation, I don't believe he actually completed the PSI in this case.
Yes, I will.
Pre-sentence investigation with the probation department. Given that, Your Honor, I'd ask that the court impose the balance of the sentence executed.
Anything you'd like to finally say, Mr. Knapp?
What's the pre-sentence investigation again? With the probationary officer, I thought I already went through that once before.
You were in a supplement investigation. You had the issue with the bike thing, and you coming up because the state let you bring the bike in and all that. And that's
Yeah. Oh, that was the PSI? I thought that was
supplemental pre-sentence investigation.
Yeah, I was homeless at the time, so it's definitely I'm making strides to do better for the community, as well as myself. It has definitely impacted me and others. And again, I've done quite a bit here. To take into consideration, please.
Yeah. Thank you.
CJ is my wife.
So,
You final remarks, Mr. Knapp?
are we willing to now that I'm a little more stable? I'm still going through this shoulder thing. I still have to have surgery and whatnot, but
You have surgery scheduled?
I'm sorry.
You have surgery scheduled?
No, not yet. There's is there the ability to start over, or not start over, but I guess continue where I left off. Again, now that I'm a little more stable and I have the ability to attend meetings and Yeah, not sleeping on the pole and whatnot. I'm definitely more healed now, so it should be easier to fall through with all this.
He's still thinking, guys. I told you he was very confused. It's very hard going to jail. Bailiff is ready, though.
I don't, given your non-compliance demonstrated in your issues with probation and counseling, it just seems like that's a fool's errand. That's complete that.
Not at all.
Because you said, look, it's not my best interest. I'm not doing it. And that's a decision you're making. And admittedly, you weren't the best place to be making that decision at the time, but you're standing by it now.
That's my point. I mean, imagine being homeless and not having anybody to turn to, and then having to go through all this stuff, meetings, and not even having a cell phone sometimes to be able to contact, or for him to contact me. Right. And I actually enjoyed Opon, except for, like I said, that booklet, where they definitely dig at your past and ask you, a lot of personal questions that you got to bring up. And I mean, that was honestly, that was the, I guess you call it a solution to my addiction. Now I've been trying to forget some of that crap. Like it felt like I was slipping, I was going to slip. And I asked, repeatedly, is there something else, and again, it's black and white. I mean, none of the story's the same.
Right. In consideration of the fact that your original sentence was 12 months and you've got 97 days of Class A credit, I find that these violations are not the worst thing. You can commit new crimes. I don't think you need the full balance of your suspended time. The court sentences you to 60 days in jail and we'll be done with it. You'll be done with probation. You'll be done with all the requirements. You'll get day for day credit, so it amounts to 30 real. And then we're done with each other and you can start fresh and go where you need to go.
Okay. Can we postpone this? I have another doctor's appointment.
The answer is no, so we're
I'll come check into the county jail.
I appreciate that. We're gonna go ahead and start that today and get it done for you. Thank you.
You're going to jail.
Please, not my shoulder. I cannot reach behind my back.
I'm sure that they'll be as gentle with you as they can. You have protocol, so.
I mean, if you can cut me from the front.
I'm gonna get 2,000.
This bailiff just came in from the fight in the hallway. Now he has to deal with this offset. Stand up, dude, or they're going to grab you.
60 days an hour. We're done with this.
Yes, sir. It's totally done. All your obligations will be discharged. Your probation will be done. You're just done though.
I was kind of under the impression that my surgery was going to be. Is there any less of a length of time, please? Just because of that, I mean, this is not easy to deal with, please.
I sympathize with you, but we're at where we're at. Thank you, sir.
We're at where we're at is what it really said. Don't look at I put the subtitles on because it's a little wonky in here. And he shut it off before we could see him get taken away. Okay. I don't know if you guys remember, but we played this Judge Link, the other day. And we're like, we got to get more of him. And I agree. He's one of my favorites. So this one isn't quite as good as the other day was, but it's still very good. You like it?
State of Indiana versus Victor Jordan, 46D04, 2602 CM 370. Mr. Jordan appears by video without counsel for initial hearing. Mr. Jordan, were you advised of your rights before court today?
Yes, Your Honor.
Do you understand what your rights are in this case?
Yes, Your Honor.
Do you have any questions about your rights today?
No, Your Honor.
What is your mailing address?
Currently it's 2-3.
And do you have a cell telephone number?
No, I don't have one right now. I'm trying to get one. I only got my mom's phone.
Okay. All right, please listen. Mr. Fredoso is going to advise you of the charge and potential penalties.
Thank you, Your Honor. There is one count. Oh, I'm sorry. There is, yes, one count alleged in the charging information. It's operating while intoxicated. It's Class C misdemeanor. The charge reads, on or about the 15th day of February, 2026 in LaPorte County, Indiana, Victor Jordan did unlawfully, knowingly, or intentionally operate a vehicle while intoxicated. The charge is a Class C misdemeanor. It's punishable by up to 60 days in jail and a fine of up to $500. Any conviction for an operating while intoxicated offense is considered a major traffic violation by the Indiana BMV for purposes of Indiana's habitual traffic violator law. It is also further punishable by driver's license suspension.
Mr. Jordan, do you understand the charge and the potential penalties for the charge?
Yes, Your Honor.
I'm entering a preliminary plea of not guilty on your behalf to the charge. Court notes that this is Mr. Jordan's third pending operating while intoxicated charge. He also is out on bond on 5 other offenses, including 3 felony causes. So the court sets Mr. Jordan's bond at $3,000 cash.
Objection, Your Honor.
Yes, sir.
I'm only out on 2 bonds. Them other charges has not came through. Them was allegations. I'm only out on the last 2 bonds that I paid for, and you're telling me now to pay $3 more $1,000. And every time I see you, you make my bonds absurd. Like,
But that's because you keep committing crimes, sir. Every time you commit a crime, you get a bond. And it usually gets bigger and bigger.
real ridiculously high, so I can't get out.
Well, the court's finding you a danger to the community, Mr.
Okay, can I say a fast and speedy trial so I can hurry up and get out of here? I don't even want to pay the $3,000 if you're not going to allow.
Question, Your Honor, this would be a aggregate bond, correct? So we would need to set the oldest case for a fast and speedy, I guess, or should we set this case? I guess.
Well, I'm not going to set either today. That'll be taken up by Judge Friedman on Friday.
I never see Judge Friedman. It's always you. I always see you, and I say fast and speedy trial to you, and you never grant my fast and speedy trial, correct?
That is not correct. I granted.
I'm asking now for a fast and speedy trial on this case.
Well,
The bond, you don't want me to bond.
Explain things, Mr. Jordan.
I'm explaining
You
nothing.
understand what I'm doing.
I explain. You explain it all the time that you don't do it the right way. So I'm gonna go ahead and let you do it whatever way you feel. But I want a fast and speedy trial on all my cases. I ain't did nothing wrong. But you're making me a threat to the community when I'm a moderate offender. Moderate. Not high.
So you want all of your cases set for fast and speedy?
Fast and speedy, as fast as possible. Jury trials.
All right.
I asked for a 10%, an 8% bond. If that's cool with you, 8% to a bail's bond. That's cool, but you don't have a bail's bond from around here. So how can I get a bail's bond?
All right. The court notes Mr. Jordan's demand for a speedy trial in all cases pending.
Okay, what about 8%? Can I get 8%?
That demand is noted on the record as being made today.
Judges have zero to do with bail bondsmen. Judges have absolutely nothing to do with their percentages. Nothing.
February 18th, 2020.
There's no justice. You don't get nobody no justice.
Mr.
I'm asking for 8%. How do I get 8%? I'm asking the judge right now, how do I get 8%? Can I get a bail bond? Can you inform me, educate me on that, Your Honor? Because I'm retarded. I don't understand what's going on.
He's reset. All of his cases are now set for February 20th, 2026. In front of Judge Friedman at 9
I got
a.m.
Judge Friedman too, just not today.
Is that a jury trial?
for giving him his jury trial dates based on Judge Friedman's calendar.
No, why I keep seeing you anyway. You don't do nothing for me. Facts, you don't. All you do is just do what you do. Sign off on shit and just pass the paper around. It's a fact.
Well, I'm sorry you feel that way, Mr.
No, man, I know 1983 complaint form. I know how to complain. You won't be on the bench forever. I know how to complain. Let's
You're
complain right now.
excused. Thank you.
All right, have a good day.
You too.
You don't do nothing for me, Judge.
46 D04, 2502 CM 483. Blake appears in person and by counsel, Mr. Denny in person.
Definitely.
Good afternoon. It's not a very good day for you, Miss Blake.
One more time, sorry.
So this isn't a very good day for you today.
What's that?
You got another driving while suspended, correct?
Judge, she has hired me to resolve her driving issues. She will be valid in.
Let her tell you what my policy is on the third driving while suspended. Let him know.
My apologies, I'm not.
No apology. Let him know what my policy is on your third OWI.
I'm not sure what your policy is for
You
that.
go to jail. You know that.
I wasn't aware of that.
You know that. Did you tell Mr. Denny you got a third one?
I communicate with him.
Did you tell Mr. Denny you got a third driving while suspended before today? Or is he learning this the first time from me right now?
He's very aware of my driving record.
And I'm not what I'm asking you. Answer my question. Did you tell Mr. Denny that you received a new third driving while suspended in Porter County before today?
Yes.
When did you tell him that?
He handles all my driving cases. He's aware of all of them. He has hired my counsel for all of them.
So this is no surprise to you. So she's going to have to post a bond. Then
Judge,
I understand where you're at, but I'm not changing my policy.
I understand, Judge. I have resolved all of her suspensions. The only one she has left is a point suspension that's up in 2 weeks. And I think that will go away once the last plea agreement, which she was saving before to bring into my office, will resolve that. We are really close and have done a lot of work to get it back.
Yeah, but she seems to believe that driving without a license, there's no consequence.
Well, Judge,
no big deal.
I have had a very stern conversation with her when she came into my office for the last case. She knows now, for sure, 100%.
It's too late, unfortunately.
Nobody puts baby in a corner.
Relapse included.
A legitimate heart
When
attack?
we last in court. All right, Ms. Blake, you're remanded to the custody of LaPorte County Sheriff. Your bond is set at $600 cash. You can post 605 to get out. You can use $600 of your cash bond to help you pay for and hire Mr. Denny
That's scary, Bobby.
or whatever you needed to pay him that he mentioned. You can use that money if he'll accept it that way. That's up to him.
Judge, I think I'm in on every case.
She's not been here for a year. That's why this is all news to me.
My last court date was,
And Judge, I've been putting in a ton of work trying to get her
I
back.
understand that, but nobody came forward and said, including your client, that she's got a third driving while suspended
the court date was rescheduled. It was postponed. I came up here 2 different times.
in December.
Judge, I've been in on this case. I entered my appearance and I've continued it. Because I've been working on getting her about.
I warned Miss Flake the last time I saw her, or the first time I saw her, March 5th, 2025, that if she gets 3 of these, she's going to jail. I can't help it that this has been continued continuously. For a year. My normal course is not give her a bond. She could sit for 2 weeks.
Hey, it's just a driving case, Judge, but I understand.
It's not just a driving case. That's what everybody thinks these are. It's just they think these are tickets. They're not tickets. It's a Class A misdemeanor. I don't make the rules.
I understand.
So she's out on bond in 2 offenses and she gets another charge. She shouldn't even be out on bond. That's not how this works.
And Judge, I would just indicate to the court, she has come from a horrible family situation. She's got nobody helping her out. She has no guidance in her life. I've been doing the best I can to give her some guidance on how to.
I'm not faulting you as her counsel. I'm faulting her and not informing you.
If I may just say, this is going to probably best for me getting my real estate license in a couple of weeks as well. This is so frustrating. I've been putting so much money out. I really think, oh, I'm sorry. I'm just very frustrated right now because this is a lying right on.
Why do you keep driving?
I had to go to probation. I had a probation meeting. I have no one to help.
You don't know anybody that could give you a ride. Where's your probation at?
In Portage. And in Valpo, actually, it's Porter County with Jim Taylor.
Where do you live?
I live in Michigan City.
So that's the deal that you made. I didn't make that deal for you. So it's your responsibility. How old are you?
25. I'm trying to get my life together.
You're a grown woman, are you not?
Yes, Your Honor. That's why
So it's your responsibility to get to your probation appointments, correct? So don't cry to me about that.
I'm just overwhelmed because I have a lot right on line. It's not that I'm sad or anything like that because I understand and I take full accountability for my actions.
Then go to jail and post your bond.
Let's go. Now, if you remember at the end of the trial, the arson trial, I told you I have a case sort of about Michael Cristofino, Judge Cristofino, but it's not Judge Cristofino's courtroom and it's not. He's not the judge. So we're going to go to that right now. Here we go.
'24 F6 1187 State versus Jackie Fischer. Good morning, Mr. Fischer.
Good morning.
All right, so we're set for entry of plea and sentencing. Is that your understanding, Mr. Cristofino?
Yes.
Okay. Well, the plea hearing. All right. Mr. Fischer, I'll have you please raise your right hand. Do you swear or affirm under the penalties for perjury that any statements you make will be the truth, the whole truth, and nothing but the truth?
I do.
This judge is starting to climb up my list. How much I enjoy watching her.
Right. Can you tell me your full name, please?
Jackie Lee Fischer.
And Mr. Fischer, are you a United States citizen?
Yes, ma'am.
And how old are you? I'm sorry.
55.
And do you read, write, and understand English?
Yes, ma'am.
Are you currently under the care of a doctor or a psychiatrist?
Yes, ma'am.
Is there anything about that treatment, any medication that you're on that would make it difficult for you to understand what we're doing here today?
No, ma'am.
All right. All right, looking then at the plea agreement on the last pages, I see Mr. Cristofino's signature, deputy prosecutor's signature. And then there's a signature line with your name under it and a signature on the line. Did you sign the plea agreement?
Yes, ma'am.
Before you signed it, did you have a chance to read it, review it, and discuss it with Mr. Cristofino?
I did, ma'am.
The plea says that you're pleading guilty to the charge of resisting law enforcement, a level 6 felony. There'll be a cap of 18 months on any initially ordered executed sentence. The state does not consent to future misdemeanor treatment. You agree to undergo a mental health and substance abuse evaluation and complete any recommended follow-up, and the parties are otherwise free to argue at sentencing. So do you understand that those are the terms of the plea that you're entering into today?
I do, ma'am.
And is this what you wish to do?
Yes, ma'am.
Right. Then looking at that charge, hopefully. All right, here we go.
Bacon.
It states that on or about October 8th, 2024 in St. Joseph County.
Crispy bacon or soft bacon? I'm both. And then anything in between. And burnt, I'm fine. Just which bacon is the best?
State of Indiana, that you did knowingly flee from Jalen Lee, a law enforcement officer, after the officer identified himself by visible or audible means and visibly or audibly ordered you to stop, and in committing that act, you used a vehicle. And so do you understand that by pleading today, you are admitting to the facts in that charge that I just read to you?
Yes, ma'am.
And that by pleading today, it means that we won't have a trial, and instead we'll proceed to judgment of conviction and sentencing today. Do you understand that?
Yes, ma'am.
If you were to go to trial on that charge, you couldn't be convicted unless the state proved each and every element of that offense. So the state would have to prove that on or about that date here in St. Joseph County, you knowingly fled from a law enforcement officer after the officer identified himself by visible or audible means and ordered you to stop. And when you did so, you were using a vehicle. So again, at trial, that's what the state would have to prove, and the state would have to prove those elements with legally admissible evidence beyond a reasonable doubt to a unanimous jury in order for you to be found guilty of that charge. By pleading guilty, though, you're waiving or giving up your right to force the state to do that. Do you understand all of that?
Yes, ma'am.
There are other rights that you're waiving or giving up, and they're discussed in the plea agreement. Again, you're waiving your right to trial before a judge or a jury. You're therefore waiving your right to see the evidence, face the witnesses, and confront and cross-examine those witnesses. You're waiving your right to compulsory process, which is using the court's subpoena power to have witnesses present to testify on your behalf. And you're waiving your right to remain silent, because if you went to trial, no one could force you to testify. Do you understand you're waiving or giving up all of those rights? You're also waiving your right to appeal your conviction and appeal your sentence so long as I sentence you within the terms of this plea. Do you understand that?
Yes, ma'am.
I wasn't a party to the plea agreement. It's an agreement reached between you and the state with Mr. Cristofino's help. So I'm not bound to accept it. I make that decision once we get to sentencing. If I accept it, I have to follow all of its terms. Do you understand that?
Yes, ma'am.
Right. You are pleading guilty to a level 6 felony, and that carries a penalty of 6 months to 2.5 years. The advisory sentence is 1 year, which is where I would typically start. I would then look to see if there were aggravating factors, which are factors not in your favor, or mitigating factors, which are factors in your favor, to figure out where within the 6 month to 2.5 year range would be appropriate. There's also a possible fine of up to $10,000. Some level 6 felonies can be treated as class A misdemeanors at sentencing. That would carry a penalty of 0 days up to 1 year and a possible fine of up to $5,000. Because this is a level 6 felony, I could suspend whatever sentence I impose and place you on probation, anywhere from 6 months to 2.5 years. If I did believe that further executed time was appropriate, and that could be time in the jail, in the Department of Corrections, or in community corrections, the most I could order would be 18 months, which is the cap in the plea. I could sentence you to longer than 18 months, but I would have to suspend anything over 18 months to probation. Do you understand all of that?
Yes, ma'am.
All right. And so, having prepared for the sentencing portion of the hearing as well, I know that there are prior felony convictions as well as prior misdemeanor convictions. And you understand then, sir, that any criminal history you do have is something that I could consider as an aggravating factor at the time of sentencing.
Yes, ma'am.
So I don't know that you were on parole or probation, but you were under a community corrections sentence at the time of this. And so you understand that any sentence that I impose in this case is going to have to run consecutively or back to back with any sentence that still might be outstanding in those cases out of Elkhart.
Yes, ma'am.
Aside from this case and those cases that are outstanding in Elkhart, do you have any other cases pending at this time?
No, ma'am.
All right, and so then with the rights that you're waiving in mind and understanding the potential penalties you're facing, do you still want to plead guilty today?
Yes, ma'am.
Do you think this plea agreement is in your best interest?
Yes, ma'am.
Did anyone force you or threaten you to get you to plead guilty?
No, ma'am.
Did anyone give you anything or promise you anything of value to get you to plead guilty?
No, ma'am.
Were any promises made to you other than those in the plea agreement to get you to plead guilty?
No, ma'am.
Are you satisfied with Mr. Cristofino's representation?
Yes, ma'am.
So you still do want to plead then today pursuant to this agreement, is that correct?
That's correct.
Actual basis then, please.
Thank you, Your Honor. Mr. Fisher, let's go back to October 8, 2024. On that date, were you in St. Joseph County, state of Indiana?
Yes.
On that date, in that place, do you agree that you knowingly fled from one Jalen Lee, a law enforcement officer, after the officer had identified himself by visible or audible means and ordered you to stop, and you used a vehicle to commit this offense?
Yes, sir.
Nothing further on factual basis.
Anything further from the state?
No, Your Honor.
All right. You understand then, sir, you've admitted to that offense of resisting law enforcement as a level 6 felony.
Yes.
And that's still what you wish to do is waive your rights and plead guilty today?
Yes, ma'am.
Mr. Cristofino, any reason that you know that Mr. Fisher should not be entering into this agreement?
No, Your Honor.
All right. And we are prepared to proceed to sentencing, so I am going to find that I am going to accept the plea. I'm finding that Mr. Fisher knowingly and voluntarily waived his rights and entered into this agreement, and that there's a sufficient factual basis for the offense charged. Mr. Fisher, I'll let Mr. Cristofino speak first on your behalf, then the state. If there's anything you wish to say, you'll have a chance to as well. Mr. Cristofino?
Thank you, Your Honor. May I make a quick record really quick? I
Sure.
forgot. I should have done this at the beginning. Mr. Fisher, you and I talked about a potential conflict of interest in this case, that being that you were on supervision out of Elkhart Circuit Court, and my dad is the judge in that court, correct?
Correct.
And as you and I discussed, that's a waivable conflict, and having discussed it with me, you're choosing to waive that conflict, and you want me to handle this case, is that correct?
That's correct.
Okay,
All right. Thank you.
thank you. Judge, by way of corrections
So
or
there we have it.
additions,
We've seen this lawyer a couple of times before, and I'm like, oh no, that's not Judge Cristofino. It's his son. His son works with his dad.
there was one correction on page 19. It indicated that my client had previously participated in addictions treatment some time ago in Elkhart. He indicated he's never completed any treatment anywhere or participated in any. So I just wanted to note that for the court. By way of mitigators, I'd note his plea of guilty and acceptance of responsibility. I also think it's a mitigator that he took initiative to get himself transported over here. Excuse me. I haven't read his letter in a while, but if memory serves me correctly, I think he basically pled guilty in a letter to the court. He also suffered some adverse childhood experiences, as noted in the PSI. He was the victim of several forms of abuse at the hands of his father. His father also had addictions issues. And I think somewhere in the PSI, it indicated, yeah, it did. It indicated that he was given alcohol at the age of 2. I just can't imagine going through what Mr. Fisher has gone through and coming out of that without having some sort of addictions issues or mental health issues. Which brings me to my next point. He does have degenerative disc disease, which is partially why he walks with the cane. He's got nerve damage as well.
His dad was the judge throughout the arson trial, Judge Cristofino.
And he's got some mental health issues. One thing I did want to note, not saying his criminal history is good by any stretch of the imagination, but early in the 90s, there were a ton of deception charges listed in there. I know through my years of practicing that in Elkhart City Court, the way they would charge check deception cases in the 90s is they would charge every single check as an individual case. So I just wanted to note that for the court. Probation's recommending community corrections. Obviously, he's not eligible for community corrections.
Right.
With the Elkhart County matter that's pending. I guess theoretically, if you wanted to do that, you could order him to report within, X number of hours after being released from Elkhart. But he's got 6 years hanging over his head there in Elkhart, and that's just on the PTR. Then on the escape, he's got obviously between 6 and 2.5 years, depending on what happens over there. So I guess what I'm asking Your Honor to consider is a suspended sentence. I'm guessing he's probably going to get DOC time there in Elkhart. And obviously this is going to be consecutive to that. He's got no credit time here for us to work with. Thank you.
Right. State's position.
Your Honor, I think the court's well aware of the matrices and the risks associated with Mr. Fisher, as well as the volume of his criminal history, and the state would ask for executed sentence, Your Honor.
I think there has to be some period of probation, though, based on the terms of the plea.
I would agree.
So, but I understand what you're asking for them. Mr. Fisher, is there anything that you wanted to say?
Yes, ma'am. I've been fighting an addiction for probably 30 years now. I don't know how to get over it. I don't. I tried to go to treatment while I was in Elkhart on community corrections, and my insurance wouldn't pay nothing of it, and I didn't have $10,000 to. And that's where the probation violation is from up there. It's because I couldn't go to treatment. I know what I did was a stupid mistake, and I apologize, to Officer Lee and Lieutenant Baker for what I'd done that night, and I apologize to the courts. But when you're in an addiction, it controls you. There's no excuse for it, but that's, if you can order community corrections or treatment, or I'd be forever thankful.
So we'll say this, Mr. Fisher, this presents a difficult situation for me in trying to figure out what the right thing to do is here, because I'm not worried. Frankly, Mr. Cristofino, those check deceptions in Elkhart back in the 90s, I know that that's how it used to happen there. And I can look at the filing date. They're all filed on the same day, just as individual cases. And I'm not sure what the reason for that was, but that's the way they chose to do it. And it is what it is. What concerns me more, Mr. Fisher, are the felony offenses that have been interspersed throughout your adult life. I think if I look back, even just back to the early 2000s, there's an escape charge then, you're facing a charge, and then just repeated dealing. And so while I do recognize that the substance use disorder has a tremendous hold on you, and it's definitely something that we need to address. And so I'm not not minimizing that, but at some point as well, Mr. Fisher, there are consequences to your actions, whether they're motivated by an addiction or not. And I also understand sometimes the difficulty of getting into the treatment that you want to get into when insurance becomes an issue, but the obligation is still on you, and these attempts have been made, as I look back through your history, to get you into some type of treatment and address these issues. And problematically, as I look through the history, whether it's motivated by your addiction or not, you are feeding the addiction of other people as well by your actions, if I look back at these older cases. So not trying to be glib about it, but you're sort of spreading the addiction then through the community, or feeding the communities, people in the community's addiction, the same addiction that you suffer from and that you understand the ramifications of. Because I would imagine, as we sit here today and you're talking to me, in your periods of lucidity when you are not under the influence of controlled substance, you can recognize that. All that being said, the whole situation around this offense, not to mention just the prior criminal history, makes this egregious, that you were out on a violation, that you were supposed to be under community correction supervision, that you had escaped from that allegedly, and committed this offense. Puts the facts and circumstances aspect of this offense also at a more egregious end of a spectrum.
So if you're going to escape, don't commit a crime when you escape, because that's just stupid.
Don't really find there to be any mitigating factors.
None. No mitigating factors. None. You escaped. You committed a crime. It was egregious. There's nothing for you right now. All that crap that you and your lawyer said, fluff that she didn't even listen to. And you know what? To be perfectly honest, I didn't really listen either.
So, with 10 prior felony convictions and noting what I just did about you being under a community correction sentence that you absconded from, Mr. Fisher, I am finding that the maximum sentence in this case is appropriate. I'm executing 1 year of the sentence, and I'm suspending the remaining 18 months. Consecutive to your placements, your sentences in Elkhart. So I don't know what they're going to do, but if they execute their sentences fully, you will have a period of probation following that, during which you will be obligated to engage in treatment. Possibility in Elkhart, and I'm asking this purely based on your experience over there, that Mr. Fisher could be purposely incarcerated over there as part, or is that something that?
It's certainly possible.
Okay. If that's the case, Mr. Fisher, then at least hopefully you will, Department of Corrections, you will be able to participate in possibility of your sentence being modified.
I can get to Bobby in 9 hours, but I gotta work today.
So I am going to order, as a condition of your probation in this case, that you assessment an IRAS assessment, based upon those assessment results, participate in any treatment that probation refers you to. So that will assess for substance use disorder, mental health issues, and they'll direct you then into the appropriate treatment following that assessment. Terms and conditions of probation will apply, so you will not use any controlled substances without a valid prescription.
No spicy
Use
coffee
any
for
illegal
Bobby.
substances
No.
or consume any alcohol. You'll submit random drug and alcohol testing and pay for that at the direction of probation. You'll report to the probation department at the times and in the manners instructed. Employment, maintain that employment. Where you will be residing, when you would be released from custody.
Probably back in Elkhart.
So I'm not going to require that you remain in St. Joseph County. We'll notify your probation officer of any change of address within 3 working days.
Is that Mr. Pitzer
Needing permission
sitting there?
outside of the county. Your probation officer visiting you at your home, your place of employment, or elsewhere. You waive rights to search and seizure and agree to submit to a search of your person or property at any time while you're on probation. You waive extradition or be returned to St. Joseph County without a hearing. You may not purchase, use, possess, or exert control over a firearm or other dangerous device. If you violate any of these conditions of probation or commit any new offenses while you're on probation, probation can file a notice of violation. That can be filed anytime during the period of probation, or even up to 1 year following the end of probation, depending upon when they learn about the violation. If I find after hearing that you did violate your probation, I could order that you serve that 1.5 years that I've suspended. That could be served in community corrections or jail, or potentially the Department of Corrections. I mean, I will tell you, if there's any probationary or community corrections sentence that you are under in Elkhart prior to starting your sentence in this.
Guys, stop yelling. Sandra's trying to sleep and she works really hard. No more yelling. Stop.
Case, or starting your
Go
probationary
to bed,
sentence in this
Sandra.
case, I guess
I'll
say,
keep them quiet.
and you violate that, that can serve to violate your probation in this case, even though you haven't started probation in this case. So I'm going to order that the 1 year sentence be served in the Department of Corrections if Mr. Fisher is sentenced to the Department of Corrections in Elkhart, and it will be consecutive to that. If you're not, then it would be served in the jail. I don't think the Department of Corrections would be able to accept you. But possibility that a Department of Corrections sentence could result in Elkhart for a portion of it. I'm going to find you indigent, Mr. Fisher, as to court costs and any fines or fees.
No, Your Honor, thank you.
Anything further from the state?
No, Your Honor.
Good luck to you, Mr. Fisher.
Thank you. Thank you, ma'am.
Good luck, Mr. Fisher.
Thank you.
And the last.
So what if it's not a mental health issue? What if 10 felonies escape, another aggravated assault while he was on escape, means he's just a criminal and doesn't have mental health issues? That's just who he is. I mean, I understand we are leaning into mental health right now, and I don't have a problem with that. But sometimes, you know, maybe it's not mental health issues. This one was from February, a little before February 20th, I think, and it's just been sitting here. And I don't exactly know. Let's just watch it. Shall we watch it? We did the 2 trials. We just did 2 trials. And I have all this backlog and I can't remember what they are.
So, okay, so we'll call the case of 26M 5000 People versus Clifford Mosser. Now, Mr. Santaloria had addressed me after our last hearings and basically had indicated that there was not sufficient information for him to argue bond. Mr. Santaloria, would you like to make a record that you were unable to get the information to argue bond?
Yes, I won't be able to argue bond on this case.
Okay. All right. Thank you very much. So, that being the case, Mr. Mosser, you have a couple of choices. The purpose of this bond is to advise you of your rights, charges, and possible penalties, and then to set bond for you. You are entitled to have an attorney argue bond on your behalf. Mr. Santaloria is not able to do that. And so you have the right to go forward today and we can set bond. What will happen in that case is that we will let the district attorney argue bond like he does. And then I will ask you some questions relating to bond only, because this is not a situation where we talk about the facts of the case or anything else. There's just certain factors that need to be considered for bond. And I would ask you about those to make a bond ruling. Your other alternative is that you could wait and be set over for the next bond hearing date, which I believe would be tomorrow, most likely. And then you would be able to have a bond hearing there in the local court, and you would be able to talk to an attorney prior to that hearing. What would you like to do, Mr. Mosser?
I'd like to do what we can today. I'm ready to move forward, and I don't really understand while I'm here, honestly. So, no.
Okay, let's not talk about that part of it. What we really just want to, that is something that you can talk with your attorney about. I can tell you what you're charged with and the possible penalties, but then you will find out more. But this purpose of this hearing is not to go into any facts of the case whatsoever. So when you are charged with an offense in the state of Colorado, you have the right to enter a plea of not guilty and have a trial either to the court or to a jury, the right to be represented by an attorney at all stages of the proceedings. If you are charged with an offense that includes a possible jail sentence and you want an attorney but cannot afford one, you can ask the court to appoint an attorney for you by filling out the application of the public defender, turning it in. If you're eligible, the court will appoint an attorney to represent you at no cost to you except a possible $25 court appointment fee.
Zach, are you coming back to Lancaster anytime soon? Lancaster, Ephrata, this area? And did you say you sort of did figure out where I work? Because if you did, and you come back to the area, you have got to go and see. It's a new one, and it's so good. I saw it last night, and it is so good.
You are presumed innocent of the allegations against you, and you will continue to be presumed innocent unless and until the prosecution presents enough evidence to prove your guilt beyond a reasonable doubt. You have the right to confront and cross-examine any witnesses called to testify against you. You have the right to present evidence on your own behalf and to compel the attendance of witnesses to testify on your behalf by having subpoenas issued by the court. You have the right to remain silent at all stages of the proceedings, including today's. When deciding whether to remain silent, it is important for you to know that anything you say can be used against you either now or later, and all of the proceedings are recorded. You have the right to, if you go to trial, you have the right to testify on your own behalf or not to testify. This choice is yours and yours alone. No one, not even your attorney, can force you either way. You have the right to a speedy and public trial. If you decide to enter any plea in your case, the plea must be entered voluntarily on your part and not the result of undue influence or coercion by anyone. If you are not a United States citizen, any plea you enter may affect your immigration status. We don't know your immigration status, and so if this applies to you, it's very important that you find that out before entering any plea. And are you a veteran, Mr. Mosser? Are you a veteran?
No.
Okay. All right. So, Mr. Mosser, you are charged with violation of a protection order. That is a class 1 misdemeanor, and it is punishable by up to 364 days in jail, up to a $1,000 fine, or both. So now our next step is to set bond for you, and we are going to start bond arguments with Mr. Jordan.
Your Honor, the charge here is violation of a protective order. It's based on the defendant having contact with his mother, Yvonne Mosser. We're very concerned about the defendant's contact with his mother here, particularly because he was just in court on Friday, February the 13th, and he was advised on a charge of violation of a protective order involving the same protected party, and he was ordered not to have contact with her. And that was case 2026 M22. And the defendant then proceeded to go have contact with his mother the next day, even though the court had just ordered him not to have contact with her. And he had already he already had pending cases for violation of a protective order. So the defendant's conduct here is aggravating. This is the type of case where he's probably looking at jail and not probation, and that would give him additional incentive to flee. And so based on that, a cash-only bond would be appropriate. We'll ask for a bond of $2,500 cash. I would also note he's not eligible for a personal recognizance bond under 16-4-104-2A because he was already out on bond. He's got multiple pending cases for violation of a protective order with the same victim. It's case 2026-M22, 2026-M21, 2026-M20, and 2026-M18. So these are multiple violations the defendant's committed in a short period of time. And the probable cause affidavit in this case says that he's been arrested 6 times in 6 days. This is his 5th protection order violation in 4 days. Also, the defendant does have a criminal history. He has, so there's a DWAI. There was a 3rd offense. That was in 2021, San Miguel County. He's got a theft conviction from 2018 in Montrose County. In that case, there was a probation violation, a complaint in support of probation revocation, alleging he didn't do his useful public service in that case. There's a harassment conviction from 2015.
I know that you don't know what I'm talking about, but we have this amusement park in Lancaster called Dutch Wonderland. And in this amusement park, there's this small house that you go in. And then there's 2 benches along the walls in the house, and you sit in the benches, okay? Well, while you're in the house and you're sitting in the bench, they turn the whole house upside down around you. So it looks like you yourself are spinning around in this house. So you're sitting completely still, but it feels like and it looks like you're spinning around in this house upside down. And they have things like this his setup. You know, his setup looks like the bicycle isn't in that house, but it looks like it could be. His setup reminds me of this little house you sit in, and it's pretty cool. I don't know, it's pretty cool, but his setup reminds me of that pretty hard.
DWAI 2nd offense from 2013. That was from Lake County, and there were probation violations adjudicated in 2015 and again in 2016 in that case. There's a conviction for driving under an alcohol-related restraint in 2011, San Miguel County. And then careless driving resulting in injury, that was in 2010, San Miguel County. I did find 2 failures to appear. Those are from 2008.
No, it's different because when you're drunk, when you're drunk, doesn't it spin sort of like this? This house spins like this. When I'm drunk and I get the spin monster, I put my foot on the floor. Like I lay in bed and I try to put my foot on the floor. It helps. Not a lot, but it helps. And when I do that, it sort of feels like I think the room spins this way. And actually, if you're in Australia, it probably spins like this. When you're drunk, your spin monster probably is like this, while ours is like this.
Again, we're asking for a $2,500 cash only bond. He should be ordered not to commit any felonies or misdemeanors as a condition of bond, and should be ordered not to have any contact with Yvonne Mosser.
All right. So thank you very much, Mr. Jordan. Okay, so Mr. Mosser, how long have you lived in the area? Okay, would you prefer me not ask you any questions? I don't need to ask you any questions. I was just trying to get a little bit more information.
I have the right to remain silent.
Okay, and yes, you do. And so I am going to go ahead and issue bond based on, I will note that, first of all, Mr. Mosser did want to proceed today without counsel. And second, that he did not, he did choose to remain silent when I was attempting to get information for bond. So the purpose of bond, Mr. Mosser, is to ensure your appearance in court and to protect the public safety. In this particular case, it sounds like you have some pretty substantial ties to the community. I mean, obviously your mom lives here and things like that. But as far as your ability to appear in court, what concerns me is not so much the criminal history, but the probation, revocations. You know, those indicate failure to comply with court orders. And in addition is the number of pending cases of violation of the protection order with the same protected party. And that gives the court concern that you would not follow court orders and may not appear in court as ordered. As far as the public safety is concerned, those protection orders where there is a protected party, they are put in place for the safety of the protected party. And they are to be followed for the safety of the protected party. And if those orders are alleged not to have been followed, especially on multiple occasions in a very short time after you were served with the protection order, and there are multiple protection orders that you were served with, that does not allow the court to feel that they can put any type of conditions of bond in place that will protect the public safety. The orders that are protecting the public safety are the ones that are alleged to have been violated. On top of that, with the pending cases, the court cannot issue a personal recognizance bond over the district attorney's objection unless I can put something in place to ensure the purposes of bond, which we just spoke about. And so obviously a personal recognizance bond, I'm prohibited from issuing it in this case. I do believe that under the circumstances, and the alleged violations, and also the conduct was a bit concerning in this affidavit as well. I do believe that the $2,500 cash only bond is appropriate in this case. I do think that there are some significant safety concerns. This protection order, it's different than the other ones. It states you shall not harass, molest, intimidate, retaliate against, or tamper with any witness or victim of the acts you're charged with committing. That'll be a condition of your bond also. So if you violate that order, you'll be in violation of your bond and could be subject to having your bond revoked. In addition, violation of that order can result in contempt of court charges against you, and it'll remain in place throughout your case, including any sentence you may serve. The most important condition of your bond here is that you must comply with all the protection orders that are already in place. The one that I entered is in addition to, not in place of any of the other protection orders. It is up to you to look at each and every protection order, find out what those conditions are, and make sure that you comply with each and every one of them, because that will be a condition of your bond. In addition, violation of the protection orders, depending on the protection order, it can result in criminal charges against you, including even felony intimidation or retaliation against a witness. So it's very, very important that you do follow the protection orders that are in place. You cannot commit any felonies or misdemeanors while out on bond. You will have to, you must appear in person at your next court date, which is February 24th, 2026 at 2:00 p.m. in San Miguel County Division G as in George. If you'd like an attorney appointed to represent you, please fill out the application for the public defender, turn it in within 7 days of your release, and if you're eligible, the court will appoint an attorney to represent you at no cost.
I give up. We had enough of her. She only has 22 more seconds, but I couldn't do the 22 more seconds. If you guys beg me to, I'll put it on at the end of the stream, but probably not. So he had 5 violations of his protection order against his mother in 4 days. I know. We didn't get to hear that because she kept talking. But that's what he did. And then he refused to talk. I have the right to remain silent. Yes, you do, sir. Yes, you do. And now you have the right to go to jail because you had 5 violations of the protection order in 4 days. Now, I have an update to pro se. Okay. We have a pro se that we watched a couple times coming through the process. So his arraignment and his status conference, we saw him, I think, twice before. All right, in 4 days. In 4 days, Sherry, he violated it. Those 5 violations were in 4 days. So this right here is supposed to be the day of trial, okay? And you can even try to remember that I said it exactly like that. This is supposed to be the day of trial for this pro se. Here we go.
Morning. We are on the record. We're also live streaming. Microphones are located on council tables and at the podium. They may pick up private conversations. The microphones on council tables can be muted. This is 25T923, People versus Ryan Trainer. Good morning.
Morning, Your Honor.
All right, Mr. Trainer, this matter comes on for a jury trial.
He has this voice that's kind of hard to, you'll see.
Also, there are warrants out for your arrest for failing to appear at your last court date. And also, you haven't complied with your bond for several months. We'll address those in a little bit. Ms. Collins, is the prosecution ready to proceed to trial?
Yes, Your Honor.
Mr. Trainer, are you ready to proceed to trial today?
Yes, Your Honor.
All right. Then we will, since we're going to trial, we'll deal with the warrants before we break for lunch. I'm going to go through our preliminary matters. Charges I have are DUI.
I know we've been at it for an hour and 18 minutes and you're worried right now. You're all sitting there worried right now because we're about to start a trial today. They both said they were ready for trial and they're ready to start the trial, but we're not. We're not going past 2 hours. Don't you worry about it.
DUI per se, no operator's license and careless driving. Mr. Trainer, you did not endorse any witnesses. Are you going to be calling any witnesses to the stand, or do you plan to?
I can't get hold of the person that did drive me home to count for the witness.
Okay. So no witnesses?
No witnesses, Your Honor.
All right. The witnesses I have endorsed are Trey Borer, Shayna Ripito, Maria Vasco, Jennifer Beckstrom, Zandria Jones, and William Doyle. Ms. Collins, of those witnesses, is there anybody the prosecution is absolutely not going to call that you don't want me to read off to the jury?
The people are not going to call Mr. Doyle and the Zandria Jones.
All right. Mr. Trainer, is there any possibility that you may call Zandria Jones or William Doyle as a witness, or should I cross them off my list?
You could cross them off your list. I have no idea who those people are.
Okay. All right, we're going to go through the other preliminary matters. Mr. Trainer, I'll give you a quick outline of how the trial works. First, we'll do jury selection. we'll put 6 more chairs up in front. We'll call 18 people to the jury box. I will ask them questions. When I'm done asking them questions, first the prosecution has a chance to ask them questions, and then you have a chance to ask them questions. The questions are to be aimed as to whether they can be fair and impartial jurors, and whether they can follow the law. Once that is done, once both sides have their chance to ask the jurors questions, you have what is called challenges for cause, which is a legal reason to excuse any of the jurors that they are for a legal reason, such as that they are prejudiced. Once we're done with challenges for cause, as long as we have 12 jurors left in the jury box, we will proceed with what are called preemptory challenges. The lowest 6 numbers, there are numbers on all the seats, the lowest 6 numbers are the presumptive jury, and that's who you can do your preemptory challenges from. You get up to 3 apiece. So let's say we've got 1, 2, let's say number 3 is gone. So our presumptive jury would be 1, 2, 4, 5, 6, and 7. Let's say the prosecution uses a preemptory challenge on number 7. That means the next person, number 8, comes into the presumptive jury. Then it will be your turn, and you can excuse any of those first 6. At any time, either side can waive and accept when they haven't used up all 3 of their preempts. If you do that, then anybody new that comes into the presumptive jury, you can exercise a preemptory challenge on. Preemptory challenges are challenges for people that you excuse for any reason. You don't have to state a reason. After we have a jury selected, I will advise them, I'll instruct them, and then we'll begin with the trial. Both sides will be able to do opening statements. For jury selection, both sides have 15 minutes for the 18 in the box. Should we need to call any replacement jurors, it's 1 minute apiece. Opening statements, both sides have 10 minutes to do opening statements. Once opening statements are completed, the prosecution will begin calling their witnesses. They will question the witnesses. When they're done with their direct examination, you have a chance to cross-examine them. The prosecution will be able to do redirect examination after your cross-examination. And if the jurors have any questions of the witnesses, they are allowed to ask them through written questions to me, and I decide if they're proper. We'll ask them after that. All right. Once the prosecution has rested their case, if you have any motions at the middle of the trial, we'll take those up. And then after that, well, I'll advise you of your right to testify or not testify. And then it will be your turn if you wish to present any evidence, okay? After that, we will do the jury instructions, and then we'll do closing arguments. All right, that's how the trial works. Regarding witnesses, Ms. Collins, are you out?
That sounds like it's how the trial should work today. And it's the day of trial, so that's how it should work.
Asking, I see Mr. Bohr at your table. Is he going to be your advisory witness?
Yes, Your Honor, it's permitted.
That's granted. Mr. Trainer, it doesn't look like you have any witnesses, so I'm assuming you don't want an advisory witness?
No, thank you.
All right. Regarding the witnesses, other than Deputy Bohr, I am issuing a sequestration order. All witnesses are to remain outside of the courtroom until they're called to the witness stand to testify. Witnesses are not to discuss their testimony with any other witness or in the presence of any other witness. Witnesses are not to have anybody from the courtroom report back to them about testimony going on in the courtroom. Witnesses are not to be watching the trial on live stream. Attorneys and parties are responsible
Nobody
for
here can be
making sure
witness.
that their witnesses understand the sequestration order. The other thing, the last thing that I have is live streaming the trial. What is the prosecution's position on live streaming the trial?
Your Honor, the people would defer to the court for live streaming jury selection, but the people do not see a reason why the rest of the trial should not be live streamed.
All right, Mr. Trainer, what is your position regarding live streaming the trial?
I'm okay with the live stream, Your Honor.
All right. All right, pursuant to 13-1-132, all criminal matters are presumed to be live streamed unless there's a reasonable likelihood that remote observation of live proceedings risks compromising the safety of any person, the defendant's right to a fair trial, and or the victim's rights pursuant to the Victims' Rights Amendment. And there is no less restrictive alternative that preserves the public interest in remote observation while mitigating the identified risk. I do believe live streaming jury selection does compromise the safety of potential jurors. Jurors would be told that they are being live streamed. The camera doesn't catch anybody in the jury box, but it does catch those that are still in the gallery. Jurors often give personal information. They give their names. They often talk about their families. They give number of schools, number of children, ages of children. They give their occupation. If it's a little different to looking around the courtroom and seeing who is listening to you while you're giving this information, then as opposed to knowing that anybody in the world could be watching you, and that there could be risk to the safety of those jurors. I also believe that if they are being live streamed, they may not be open and honest in their questions during jury selection, which I believe could infringe on the defendant's right to a fair trial. I don't think there's any less restrictive alternative other than not live streaming jury selection only that would mitigate the risk and preserve the public interest in remote observation. So we will not live stream jury selection only, but we will live stream the rest of the trial. We will, when we recess to get the jury, we will go off live stream and we will stay off live stream until we have a jury selected. We will go back on live stream right before I swear the jury in. That's all I have for preliminary matters. Ms. Collins, does the prosecution have any preliminary matters?
Your Honor, I do have the full copy of the certified driving history that I plan to admit, but I also have a redacted copy. I don't know if the court wanted to, or if we wanted to discuss which one to be shown to the jury at this time or address it at a later time.
Colorado. This is Colorado.
Yeah, we can address it now. Has Mr. Trainer seen that?
I have not, Your Honor.
Did you get your discovery, Mr. Trainer?
I did.
Okay.
It was probably in there.
I can show him.
Can you show him the unredacted copy and the redacted copy? Speak to who?
Ryan, Mr. Owner.
Sure.
I'm not 100%, but I think that's his mom. Or dad. I can't tell. And now it goes sideways. We were cruising fine.
All right. After speaking with your dad, Mr. Trainer, is there anything from you right now?
I'd like to request to hire an attorney.
All right.
That's still an ability.
Why have you waited till the day of the trial to ask for an attorney?
I figured I could do it by myself.
What steps have you made to retain an attorney or to apply for the public defender?
Steps that we've taken, we contacted them over the weekend or the past several days to request an attorney.
Well, why did you wait until the last moment? You first appeared in court on June 2nd of 2025. We're 8 months later and 2 days before
saw that
trial.
on June
You
2nd.
attempt to get an attorney to represent you?
I figured I could do it by myself, Your Honor. That's why I tried to do it that way.
Now try to
Have
think
you
of
retained
every
anybody?
judge you know.
I have not yet, Your Honor.
Have you talked to anybody?
Yes, my mother contacted the Consilia office for an attorney, and they said that they couldn't do it like the day before the trial.
Have you talked to any other attorneys?
I have not, Your Honor.
What efforts have you made to get an attorney before this weekend?
None, Your Honor.
Ms. Collins, what is the prejudice to the prosecution? And what is the inconvenience to witnesses of at this late date, the defendant requesting an attorney, and also what's your position regarding that?
Your Honor, at this time, the people are ready for trial, and we have 4 witnesses, 2 of which are expert witnesses, including a CBI forensic toxicologist. At this time, everyone is available today. I do not have Ms. Beckstrom's availability in front of me right now, as I did not anticipate needing it. So should the trial have to be reset, there could be potential motions filed to move the trial date based on future witness availability. Once all the witnesses are contacted, the people would object to a continuance simply because all of the witnesses are here and available, and Mr. Traynor has had since this case started to hire an attorney, which I believe was back around June or July. So the people would be objecting, but ultimately defer to the court. The people don't believe that a continuance would severely prejudice their case, but it just might impact witness availability.
You suck as a lawyer.
All right, thank you. At this time, Ms. Collins, I know you would not have talked to your witnesses probably, but do you know if any of them have vacations or anything like that planned, or have you not even discussed that?
I have not discussed that, Your Honor.
Okay. Mr. Traynor, is there anything else that you want to let me know regarding your motion to continue the trial to get an attorney?
No, there's not, Your Honor.
All right. Mr. Traynor, do you understand that if I grant your continuance, that you would be waiving your speedy trial and a new speedy trial period would begin?
Yes, I do, Your Honor.
All right. Well, under People versus Brown, 322 P. 3rd 214, there are 11 factors to continue to consider when the defendant requests to continue a trial to obtain counsel. First are the defendant's actions surrounding the request and apparent motive for making the request. So the defendant's first appearance in court was on June 2nd, 2025. He entered a not guilty plea on October 27th, 2025. At his first appearance in court, I asked him if he wanted to get an attorney to represent him. He said no. He entered his not guilty plea on October 27th. Again, he didn't want to get an attorney. I advised him pursuant to People versus Arguello on November 17th, 2025, again advising the defendant of his right to an attorney, asking him if he wanted to talk to the public defender before making the decision to proceed without an attorney. And the defendant still did not want to have an attorney. We also had a court date on December 1st, 2025, where I don't know offhand if I asked the defendant if he wanted to get an attorney, but he made no mention of getting an attorney. Defendant failed to appear at his pretrial readiness on February 9th. So today is the next date in court. The motive for making the request is that the defendant at the 11th hour has wanted to get an attorney. Factor number 2 is the availability of chosen counsel. The defendant has not retained counsel. The defendant has not applied for the public defender. The defendant's mother has talked to Joe Concilia's office, who indicated they could not represent him with trial today. So there is no attorney. The next one is the length of continuance necessary to accommodate chosen counsel. I really don't know what that would mean, since the defendant has not actually retained anyone or applied for the public defender. The next factor is the potential prejudice of a delay to the prosecution beyond mere inconvenience. Ms. Collins has indicated they are ready to proceed. There are a number of expert witnesses. She does not get their scheduled, but she has indicated that she does not believe that her case would be prejudiced, but witnesses would be inconvenienced. That is the next factor as well. Inconvenience to witnesses because of the defendant's timing of asking for an attorney on the morning of trial. The prosecution has not had a chance to discuss with her witnesses what their availability is. And one of her witnesses, who's her expert in the field of forensic toxicology, is not here yet, so she doesn't even have a chance to be able to speak with that witness out in the hall. I will say there is inconvenience to witnesses. The age of the case is approximately, well, let's see. The age of the case is about 9 months. It's been through the system. From the date of the offense, I believe it's May of 2025. There have been no other continuances granted in this case. As I said, the timing is on the date of on the day of jury trial, when there were numerous times before this that the defendant could request time to get an attorney. The impact of the continuance on the court's docket, it will not impact the court's docket. This is not a VRA case, so there is no victim to position to consider. Final factor is any other case-specific factors necessitating or weighing against further delay. I haven't heard of any. And I can't often think of any. I mean, honestly, I think the factors in Brown go against the defendant when I weigh everything together. However, I am, if he's willing to waive his right to speedy trial, probably willing to continue the case. Mr. Traynor, do you understand that you have a right to a speedy trial, which is a trial within 6 months of entering your not guilty plea?
I do, Your Honor.
Do you understand that by requesting a continuance today to get counsel, that you are waiving your right to speedy trial, and a new speedy trial period of 6 months will begin from today's date?
I'm aware, Your Honor.
Has anybody pressured you to waive your right to a speedy trial and request a continuance?
No, Your Honor.
Right. And you don't have an attorney, but have you talked to family members or friends or anybody else that you want to talk about that is enough as you would have liked to?
I have, Your Honor.
Are you asking to waive your right to a speedy trial and continue this trial today?
I am, Your Honor.
But I will find that Mr. Traynor understands his right to a speedy trial, that he is knowingly, intelligently, and voluntarily waiving his right to a speedy trial, and is asking to continue his trial to get an attorney. Although the factors do weigh against him, I will grant it this one time.
That's crazy.
And I agree with the prosecution.
What?
The prosecution is ready to proceed today, and I can anticipate that perhaps, especially because of an expert witness, the prosecution may need another continuance. Ms. Collins, did you have something?
Your Honor, if I could have 5 or so minutes, I could step into the hallway and attempt to call some of the witnesses to ascertain their availability before we reset the dates.
All right, before we do that, why don't we see what potential dates we're looking at?
Okay.
And that's fine. We can take a recess and you can do that.
I can't believe what we're seeing. I cannot believe this judge did that. I can't believe it.
Give her a couple of them and see what she's got. So she can talk to them, yeah. All right, why don't we take a 10-minute recess? Ms. Collins, you can try and get a hold of your witnesses and see what sort of availability issues they have. After that, we'll get the dates and then we'll address the warrant.
All right, thank you, Your Honor.
We'll be in recess for 10 minutes.
Think of any other judge you know. Anyone. Pick any other judge you know. On the day of trial, they say, oh, wait, can I have a lawyer? And the judge says, sure. Sure, why not? Now, we saw him, and it was interesting in his other, in the upcoming ones, in the past live streams, we saw her tell him, do you want a lawyer? Do you want a lawyer? No, I don't want a lawyer. I want to do it myself. Lawyers, they screw me over. It's a conspiracy. They all got it out for me. They don't put the evidence I want forward. There is a judge in Colorado, it might be Boulder, that I call the kindergarten judge.
All right, we are back in the record.
She's YouTube. I can't remember her name.
23. Ms. Collins, have you had a chance to, or were you able to get a hold of any of your witnesses?
Your Honor, I was able to get a hold of 3 of them. I haven't received a response from the CBI forensic toxicologist. However, at least for the 3 I was able to speak to, both May 26th and May 19th work. I do anticipate Ms. Beckstrom to answer me today, so should I need to file a motion, I can do it very timely.
All right, let's go ahead and we will set a jury trial, a pretrial readiness conference, as well as
Judge Babcock.
Mr. Trainer, how long do you think it's going to take you to get an attorney to represent you?
I'm gonna head to the public defender office as soon as I can after I leave here.
All right.
Or that.
So we'll give you an appearance at council date in a week as well.
Judge Khan probably would have said yes. You're right. You're right. Wonder what Judge Dad would have said. I wonder what Judge Fish would have said.
Hearing the council February 25th at 8:30.
Right, we will
Judge
continue
Boyd
to
would have
those
said.
dates. Mr. Trainer, all 3 of those dates are court appearance dates for you. If you fail to appear in person for the jury trial, it will be a waiver of your speedy trial. Do you understand, sir?
I understand, Your Honor.
All right, now regarding the warrant, Mr. Trainer, is there anything you would like to say regarding whether I should take you into custody or recall the warrant?
Oh, jeez. I wonder if she's going to take him into custody today, guys.
On that day at around 1:30, I did have a diabetic low, which hindered me from making it to court at 2:30 that day.
All right, what about all your violations for your bond conditions with RMS?
On those, I got really sick and kind of got scared about going back because I got really sick from back in December from my diabetes. I didn't have any insulin. So I figured I was just going to keep blowing hot into the breathalyzer. And then I finally got insulin, started feeling better, but then got nervous about going back and didn't know how to proceed about that.
How does not having insulin make you have a hot blowing in? How does it have alcohol?
What happens is in your body, it becomes really acidic, developing like your sugars don't process how like with the pancreas, how it normally processes your sugars, it stops it from processing right, and it causes your body to like have alcohol basically in your blood.
Okay. All right, what's the prosecution's position on the warrant?
Your Honor, the people acknowledge that potentially very low insulin levels could cause a false positive, but the people will also note that Mr. Trainer did plead guilty to a DUI in
You are
Colorado
a
Springs
terrible
back
lawyer.
in June. So not only is he on DUI probation, he's also on bond for this DUI that he picked up right after. It's extremely concerning to the people that he has not been complying with bond since December 17th, and that he did fail to appear and didn't file anything with the court or let anyone know. If the defendant was scared to go back, I assume he would have a probation officer from Springs that he should be keeping in touch with as well. That might have been able to help guide him through the process. So the people do believe that all of the allegations in the RMS affidavit combined with the failure to appear in this case are concerning, and the people would ask the court to take him in on the warrant.
Right, thank you. Right, Mr. Trainer, the prosecution has very valid points here. I will give you one break here. I'm going to recall the warrant. However, your supervision level is going to be upped. You're to be on level 3 DUI supervision, and you are to do day reporting. Any other violations, I will take you into custody. The warrant will be executed. I will
No, you
not
won't.
recall any more
No,
warrants
you
for
won't.
you. You are to go to RMS as soon as you leave the courtroom today. After that, you are to go to the public defender's office to fill out the application. All right?
Yes, Your Honor.
All
Thank
right.
you, Your Honor.
Anything else on this matter from the prosecution?
Not at this time, Your Honor.
Mr. Trainer, anything further?
No, Your Honor.
All right, we'll be in recess then.
He could assault the prosecutor on the way out the door and still not go into custody today. I don't think I've tried. Oh yeah, I do play Hawaii sometimes. Remember, I do play Hawaii cases. Remember the? I don't know how to. Remember, it starts off that way. You don't remember the beginning of Hawaii court? It's so good. They say the whole long words. I don't know what they are, but yeah, I can only show what I listen. I check Alaska all the time. I do have some exciting news for you, and nobody is going to think it's exciting, but it is so freaking exciting. Judge Frost, guys, I got it set up that I have every single time Judge Frost goes live. I got him. He is way high on my list. He's way high, and I got him. I got him now. I cannot believe I got him. And he streamed on the 2nd or the 3rd, so I have like 6 hours of him waiting for me to watch, but I'm not going to touch it yet because we still have February to get through. So it's sitting there, just sitting there. It's been sitting there for a couple days waiting for me. Yeah, thank you, Zach. We already knew that one. Forget it. Yes. Yeah, it was. I think it might have been an appellate court or a Supreme Court. I don't know. But yeah, we had Willie. Willie came. Willie was from from Hawaii, and Willie used to come in, and we call her, right? It was a her. We call them Willie because their name was like was like that. It was like what Zach just put up there. All right, guys, if you're here to see court is over. I have so many more to show you, but we have to stop. We've been here for a while. I have to respect your time. So Colorado is getting to me. I have all of Indiana going, but I can't get Colorado because they keep expiring their keys. They keep expiring their links, Zach. So I've given up almost on Colorado. If I feel like getting Colorado someday, I will. But mostly I'm just going to stay in Indiana and Georgia. I love Georgia. and Wisconsin. Indiana, Georgia, and Wisconsin. That's what you're going to get most here. I will play YouTube judges if you guys tell me you want to see something, but I usually never play YouTube judges. You're going to come here, you're going to see judges you don't see nowhere else until they start playing them, because I did, which happens. You're going to see Judge Fish. I do love Judge Eric, so I will get Colorado for him when I feel like it. I just haven't seen him in a couple months. Thanks for coming out, guys. Bobby, I hope you feel better. CJ, I love you. A lot. I'll see you I'll see you tomorrow morning. We'll do some more. Bye, guys. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so